Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Now, it's always a pleasure for me to look at a new edition of Cook on Costs. It's one that I've sort of grown up with in my legal career. And we've got the new edition now of Cook on Costs for 2015. The subtitle remains the same, A Guide to Legal Remuneration in Civil, Contentious and Non-Contentious Business. And this new edition has been edited and written by Simon Middleton and Jason Rowley. And it is Jason Rowley. You probably may see his name as Simon Rowley. That was a little bit of a mistake, but it should have been dealt with. It is Simon Middleton and Jason Rowley. Now, my wife Elizabeth and I looked at the book and said, well, we've reviewed Cook on Costs before. What are we going to say about this edition? Because there have been some changes. So we've given it this title for the review. The Classic Reference on Costs, fully updated, and an enjoyable read. And I have to say it still remains to me a very good book to read, because most book on costs can be pretty boring. This one isn't. There's the front of it, there's the spine, and then there's the back. There's some nice little comments on the back. Cook on Costs, first published 33 years ago, is well established as a practical and up-to-date guide. Exactly so. The 2014 edition was the first edition with the two new people for the editorial team, and they've done very well taking over the job. Here is the book itself. Let's start at the back. A lot of detail in the index there. It's nice to know that this book is well received in court still. There's an appendix there on the some legislation, the Solicitors Act. If we go to the front, there's some nice reviews in the inside front cover, some very substantial and very pleasant reviews about the book itself, because it's known to many people as a friend as much as anything else. Details about the authors, and then there's the cover there. Then you've got a preface, which has been written by Jason Rowley, and then there's a preface to the previous edition by Simon Middleton. And then there's a preface to the first edition way back in 1991. I can remember it well even now, when Michael Cook wrote the very first edition. Excuse me. There's the contents section there, and you see you've got a lot of chapters as usual. All the usual suspects are here. I haven't changed it that much. You just go through again. Quantification of costs. Fixed costs of an important area now. Again, you see we're getting up to the later chapters there, and then the final chapter, chapter 41 on arbitration, and then you've got the appendix right at the back, and then cases and statutes, CPR table. Actually, the cases are at the end, not at the beginning. They're at the end of that little group of points, and then you've got part one, solicitor and client, and then you launch into the book. Nice bit of paragraph numbering at the side so you can find things, a good introduction to explain things. You haven't got extensive footnotes or anything like that in this book at all, but what you do have is a great deal of reference material in the particular paragraph numbered sections, and it just runs all the way through. And with most of them, there's a nice conclusion to each of the chapters just to round everything off. As I say, it's a good read apart from anything else. It's not a difficult book to read. I found it quite helpful, actually. I haven't used it that much in court because I haven't had that many cases where we've had to eventually get to it, but I certainly have used it as a background reading, a primer for myself, just to remind myself of where we are with some of the problems we might face. Because if you're reading something like the White Book or the Green Book or one of the practitioner books, they do send you to sleep pretty quickly, frankly, and I do find the English not the easiest to understand, with great respect to those who've written the practitioner books, although they've improved in recent years. But this book itself is much more down to where you are as the reader and what you're basically thinking about with the problems you've got on costs. Now let's say what we think about the book from our review. To paraphrase the words of Michael Cook himself, the original author, of course, of the numerous previous editions of this definitive work, the matter of cost should be written about in an interesting, coherent and digestible way. Treading almost literally in Michael Cook's footsteps, the new authors, Simon Middleton and Jason Rowley, uphold this tradition admirably, or admirably rather, in this new edition for 2015. Quote, "We have tried to continue Michael Cook's approach of making the text enjoyable to read," says Jason Rowley in his preface, adding that the book will continue to express views and opinions on the merits or otherwise of legislation, policy and cases, with a view to explaining why the law of costs is as it is, and also to explain why an answer is as it is, rather than simply stating what the legislation says or what has been formally decided in a particular case. And so the new edition of the book therefore leans heavily towards interpretation and commentary by way of creating a more practical and accessible approach to the factual material on costs. This is nothing if not a refreshing point of view for practitioners at the coalface, whether barristers or solicitors. Like members of any other profession, they are understandably concerned with one of its more important aspects, remuneration, and the need to understand how the rules affecting it are applied. Very important consideration, obviously, for all of us. The publication of last year's 2014 edition, that was the first published under the new editorship team, coincided with significant procedural amendments introduced in April 2013. As was the case with last year's edition, this new 2015 edition has been restructured and rewritten, particularly the chapters on children and protected parties and family law proceedings. And of course, the book was available towards the end of 2014, and I'm recording this in the spring of 2015. In the words of the publishers, who are LexisNexis, the text has been updated to reflect the growing pains of the 2013 CPR amendments, civil procedural amendments, and where there is no authority or clear procedure, practical guidance based on experience is helpfully provided. Divided into 5 parts, the book, of almost 900 pages now, deals with every conceivable aspect of costs, from issues between solicitor and client to funding, settlement, awards and the quantification of costs. That's towards the end. Part 5 focuses on special cases, including children, LIPs, litigants in person, arbitration and family proceedings. And writing in the preface to the 2014 edition, the co-author Simon Middleton points out that the authorship of the book changed hands in a year that has seen the most radical overhaul of costs since the introduction of CPR in 1999. It's appropriate and timely that this long-established, highly regarded and authoritative work of reference on costs has been carefully modernised to reflect current cost practice, and it's to be welcomed. It is a first-class book and remains so. No practitioner, in our view, should be without this brand new, carefully updated Cook on Costs 2015. And the law is as stated the 1st of October 2014. So as I say, it was out towards the end of last year. It's about, as I said, running up to nearly 900 pages in total. But you've got an awful lot of very useful stuff. What I do like, for instance, this is about fixed costs, medical fees. You do get the cases, and what Michael did and what has been continued is, with the case law, it actually makes it quite easy to understand what has happened with a particular case law authority. And I have found that helpful in practice myself when I've been dealing with making some submissions in court. What you've got again, of course, at the back is a pretty detailed index there. And at the front, as I say, you've got all of the various parts nicely set out, and a lot of case law, which is also quite helpful. At the end of the day, a judge will be looking very much at your own case, which you're actually presenting in court. But case law does have an important role to play sometimes, depending on what the issue is which the court has to determine. I'd like to thank the 2 authors, and Michael Cook, of course, as well, because he started this, and he's been basically a friend to me with the books all the way through my practice. So I'd be very grateful that this is still continuing. Thank you to all, and of course obviously to LexisNexis and Butterworths, who I should have mentioned as well, for producing this first class new edition. Thank you. Bye bye.